All right, folks, buckle in. This one is already heavy, a serious charge, a massive bond, and a defendant walking in with strong family support. Let us see how this plays out in court.
Court calls the case of the people versus Preston Jackson.
Good morning to this honorable court. Carla Marble, P number 62755, on behalf of Mr. Jackson. Mr. Jackson is here.
All right, sir, state your name.
Preston Jackson.
Thank you.
Notice how the attorney quickly mentions being retained just yesterday. That's not just small talk. It's a strategic move to buy time and signal to the court that they're still catching up on the case. Smart or stalling? What do you think?
Yeah, and I've recently been retained as of 6:30 yesterday afternoon. I did do appearance and a substitution on this particular case. I haven't got any discovery on this particular case, so I will be asking for another probable cause.
All right. I need you to fill out a green sheet, but I'll
Okay.
process. Probable cause conference, September 11th. Will that work for you, counsel?
Yes, September 11th will work.
September 11th, 2025, 9 a.m. Bond will continue.
Your Honor, can I address the
Please.
issue of bond?
Go ahead.
Your Honor, so Mr. Jackson is here, and I do understand the charges, but the purpose of bond is twofold. The first purpose of bond is to ensure that a person shows up for court. Mr. Jackson does not have a capious history. He has strong family ties. His wife and his mother-in-law are here in the front row. And the second prong of bond is for the protection of society. Mr. Jackson does have a record, but it's an old record. It's from 2016. So we're just asking for a 10% provision of the bond. That bond is extraordinary. $500,000.
$500,000 bond. That's not pocket change. When defense attorneys highlight a family ties and no flight risk, they are basically trying to chip away at that number. But big charges mean big resistance from the prosecution.
Dollars is extraordinary.
Response?
Your Honor, support receipt of our bond request form or bond information form.
I am.
The facts in this case include that the defendant stabbed the victim in the head multiple times and then
Where? In the head?
in the head.
Yes, I got it. Go
And
ahead.
then stole his property.
And there it is. The prosecution comes in swinging stabbing allegations, prior felonies, and firearm history. Notice how the language is sharp and direct. This is how prosecutors anchor the judge's attention on danger to the public.
I understand the defendant was previously sentenced to prison on a felony firearm, felon in possession of a firearm case, as well as a 2010 liquor versus controlled substance possession of marijuana, which we're concerned about firearms cases. I do believe the bond is appropriately set in this matter, and the 2016, I'll take that back. I do believe the bond is appropriately set. It's an extremely serious case, and people are extremely concerned for the victim's safety.
Anything else?
Your Honor, at this point, these are just allegations.
The defense plays the just allegations card, a classic move. Remember, a defendant is presumed innocent until proven guilty. But bond hearings aren't on T about guilt or innocence, they are about risk. Flight risk versus public safety.
Right? And
They are.
they're just allegations. And one of the things about bond is twofold. Is he's not a flight risk. She didn't argue that he's a flight risk. He plans to fight this case. He has retained counsel. And the protection of society, his
If
background.
somebody was stabbed in the head multiple times, as alleged in this case, the court would consider it a danger to the public. Motion for bond reduction denied. Bond will continue.
And just like that, bond reduction denied, no long debate, no gray area. When violent allegations meet a serious criminal record, the odds of a bond cut drop fast. Would you have ruled the same way?
Thank you, Your Honor.